rise. Court of Appeals, Division 1 is now in session.
Good morning. Please be seated.
Good morning.
This is the time set for oral argument in Saban Rent-A-Car LLC et al. Versus the Arizona Department of Revenue, our tax number 16-0007. We have previously sent out an order allocating an hour and a half for this argument in its entirety with parameters designated by issue. And I trust you all got that and are ready to proceed on that basis. We have gone through the record. We have read the briefs submitted by the parties and amicus participants. We have conferenced the case and discussed it at length. So we're pretty familiar with the underlying facts and the proceedings below, so please keep that in mind as you make your arguments here today. We are recording these proceedings both by audio and video means. The video will be available on YouTube at some point in the near future for your reference. As you approach the podium to make your arguments, however, I would appreciate if you would identify yourself and the issue to which you are addressing. So when we look at this later, or anyone looks at it later, they have that context. With that, we will start with the validity of the tax under the constitutional provision. And
Governor, just a housekeeping matter before
Yes.
we begin. I just wanted to make sure that the court also received the notice that we filed indicating who would be arguing what issue.
we did, Mr. Hudson. I have it here. Thank you. Yeah. Okay.
Good morning, Your Honors. May it please the Court, Thomas Hudson on behalf of the Arizona Department of Revenue. I will be addressing the first issue this morning concerning Article 9, Section 14 of the Arizona Constitution, and I hope to save 5 minutes for rebuttal. Your Honors, the first issue in this case this morning is about a group of plaintiffs stretching a constitutional provision well beyond its intended purpose. And this can be seen in several ways, two of which I plan to focus on this morning. First, there is a straightforward, common sense interpretation of Section 14 that demonstrates unequivocally that the asset tax is not subject to Section 14. Second, if you stretch Section 14 to reach the asset tax, it will necessarily reach other taxes that plainly fall outside of its scope. Now, turning to my first point, the key language in Section 14, taxes relating to registration, operation, or use of vehicles on the public highways or streets, has a history and context that informs its meaning. In particular, we know from the Hayden-Cartwright Act and the publicity pamphlet that voters were concerned with the taxes and fees that the government charges in connection with registering, operating, and using vehicles. And this category of taxes is long-standing and well understood. For example, Arizona law defines what it means to be a vehicle operator. And to operate a vehicle, a motorist must pay the necessary license fee. That's an example of a vehicle operation fee.
But the statute doesn't, or the constitutional provision does not say taxes, fees, one must pay to operate or use a motor vehicle. And if that's what I understand your briefing to ask us to define relating to mean.
I don't think so, Judge Johnson. I think my point is that the phrase related to is on its face ambiguous. And for us to understand what the voters were getting at, we've got to look to the context and history. And my point is that this category of taxes that we're talking about is a well-understood category of taxes. And again, just another example, when someone goes to register a vehicle, you have to pay their registration fees, and you have to pay whatever use fees the government has decided to charge. And that category of taxes has several properties that distinguish it from other types of taxes, and two of those are important to this case. First, we know from the publicity pamphlet that the voters were concerned with revenues derived from road users. Tellingly, every tax, every fee that everyone agrees is subject to Section 14 consists of a tax or fee that motorists pay to register, operate, or use their vehicles. They are all revenues derived from road users. Second, whether the necessary registration or use fees have been paid, that is a feature of the vehicle itself. So what that means is once the necessary taxes to drive lawfully in Arizona have been paid on a vehicle, any motorist who has the requisite license may lawfully drive that vehicle on Arizona's roads. The ASTA tax is markedly different. First, it is not a tax that any motorist ever pays to register, operate, or use a vehicle. Second, when a motorist goes to rent a vehicle, whatever fees the government requires for the car renter to lawfully drive that vehicle on Arizona's roads, those have already been paid. So decisively, and in sharp contrast to actual vehicle registration, operation, or use fees, whether or not the car rental business pays the ASTA tax has no effect whatsoever on whether the car renter may lawfully drive on Arizona's streets and highways.
And that's because, under your argument, the car rental agency has already paid all those taxes to enable the car to drive, to be
exactly. Whatever taxes are necessary for the car renter to drive have been paid, and what that means, and the ASTA tax is not one of those.
Correct.
But
Well,
it's not. No one cares whether the ASTA tax. I mean, if the car renter gets pulled over by an officer, the officer is going to ask to see two things: the driver's license and the car's registration. The Department of Revenue may care whether the ASTA business tax gets paid and may file a lawsuit to try to collect it. But as far as the car renter is concerned, and as far as whether the car renter may lawfully drive on Arizona streets or highways, no one cares whether the ASTA tax has been paid.
now, okay, and I take it that all of the taxes that Arizona actually does divert or pour into the highway fund fall into that category.
Correct.
That being said, what does relating to mean? I mean, how do we need to presumably say what it means in order to decide whether this surcharge falls within it or not?
Well, a couple points on that. One, as I say, it is ambiguous, so we have to look at the context. And what it's getting at is saying, here's a category of taxes, and if it's related to that category, then it has to go to the HERF. But I don't think it necessarily turns on whether you construe that phrase narrowly or broadly. What matters is correctly characterizing the category of taxes that we're talking about. Let me give you an example, Judge Johnson. If I say all mammals related to the canine family, that's a broad category in some senses. It includes toy poodles to Great Danes to American gray wolves, but it doesn't include cats. And that's what we have here. When we say taxes related to the registration, operation, or use of vehicles related to that category, it has to be something that is in fact related to the category. The ASTA tax is a completely different animal. It's not something, as I said, it's not something, a tax that has to be paid by anyone to operate, register, or use. It's a completely different animal. And in fact, precisely because no one cares whether that tax has been paid in terms of being able to register, operate, or use a vehicle, it is completely unrelated to vehicle registration, operation, or use. And I'm happy to answer more questions, but
Is that because the surcharge is a business privilege tax?
In part.
That's another layer of removal.
It is another. In fact, it makes it easier precisely because it's a business tax. It's a tax that car rental companies pay for the privilege of operating. It's not any tax that any motorist ever pays for the privilege, but it's more than that. It's going back to my point. A car company's failure to pay the ASTA tax doesn't prevent the renter from lawfully driving on Arizona's roads. So whether the asset tax has been paid is literally irrelevant to whether the car renter may lawfully drive. And it's for that reason that it is completely unrelated to vehicle registration, operation, or use. And if I may then, let me turn to my second point, which shows exactly the same thing. Namely, as I said at the outset, if you construe Section 14 to reach the asset tax, Section 14 necessarily covers other taxes that fall outside of its reach. They focus on the language that says the asset tax, they say it's related to vehicle operation or use because it applies to businesses that rent vehicles designed to operate on the highways or streets. So under their theory, any tax on any business that involves a transaction that enables motorists to use the public highways or streets is subject to Section 14. But that means, if that's true, that means the 1935 TPT on car rentals that existed when the voters enacted Section 14 is subject to that provision, even though the voters were told otherwise. It means that the tax on standard auto leases and auto sales is subject to Section 14, even though cities, municipalities, and the state for over 90 years has imposed taxes of that nature without anyone ever suggesting they're subject to Section 14. And it means that the general use tax that we included in our supplemental citation would be subject to Section 14. Even though, and what that would mean, of course, is that the Department of Transportation, which collects the tax, could not deposit it in the general fund, even though that's what Arizona law requires. And we would submit that that means their interpretation leads to a whole host of absurd results that demonstrate their interpretation cannot, an absurd result that would wreak havoc with Arizona's tax system, and therefore their interpretation cannot be correct.
What cases other than the 3 Ohio cases interpret an anti-diversion measure like ours that has relating to?
The Thrifty didn't have the related to. I think those are the only 3 that have the related to. And if I could just briefly on those cases, if the panel's interested, make a point, which is you have Beaver, which involves fuel, which is a commodity, and it's called out in the specifically. And in Ohio, their fuel taxes had already been characterized as privilege taxes. So it's
a privilege tax case. So to that extent, it helps Saban.
It doesn't. It doesn't because
it's fuels in it.
It's fuel. It's fuels and the other 2 Ohio cases, the Ohio Trucking and the Fowler, are cases that dealt with the provision here: registration, operation, or use. And one point to note about those cases: the Ohio Trucking and the Fowler cases, those cases were harder than this case. In both of those cases, Ohio Trucking involved the certified abstract record fee. Some motorists had to pay that fee in order to register their vehicles. Fowler Trucking involved the fee to reinstate your proof of financial. Some motorists had to pay that fee in order to register. What the Ohio court said is, but ordinary motorists don't. In this case, no one has to pay the asset tax in order to register. So in many ways, this is an easier case than the 2 Ohio cases that support our position. And unless the panel has more questions, I'll save my remaining time for rebuttal.
Thank you, Mr. Hudson.
Good morning, Your Honors. Taylor Young on behalf of Saban and the rental car companies in class in this case. The defendants in this case have focused on this notion that the term related to is inherently ambiguous. That's not true. The court has not found in the past that the term related to is inherently ambiguous. In fact, the courts had no problem defining the term, looking to dictionary definitions, and characterizing it as a broad term. And I think in this instance, we just simply need to focus on the plain language of the constitutional provision.
Well, what do you think it means then? What does relating to registration, operation, or use of a vehicle mean?
It means precisely what it says, which is do we have an excise that is related connected to operation, for example, operation of a vehicle on the streets. And I think one of the things on public highways, and one of the things that I think is important in this case is the car rental surcharge statute uses that very specific language about cars that are designed to operate on the streets. And so it ties directly in, the language ties directly in to that constitutional provision. I mean, it's very difficult to say that this is a tax that is not related to the operation of a vehicle on the streets when in fact the surcharge itself talks about it.
It doesn't cover farm vehicles,
It doesn't cover
carts.
It doesn't cover certain motor vehicles. That's true.
But what about a parking lot fee? Is that relating to operation or use of a motor vehicle?
I wouldn't think that a parking lot fee, by definition, would be related to operation or use of a vehicle. And in this instance, one thing that I would point out is that when a consumer comes in and rents a car, right? By definition, they're going to operate the vehicle. They leave and instantly go onto the streets, and that has an impact on our streets. And that was the motivating factor behind this. If we get beyond plain language, is a discussion of what are the impacts on the highway funds? How can we make sure that our highway funds are continue to support our streets and support the tourism industry, which, of course, plays directly into this case. So,
What about Mr. Hudson's example of the sale of vehicles and the transaction privilege tax that's been collected for 70 plus years on the sale of retail sales?
yeah, in this instance, I think what we're looking at is broad language that's related to the simple operation of the vehicle rather than a purchase of a vehicle, for example. And I think that would be the distinguishing factor.
Why does the measure include an express reference to fuel? If you have to buy fuel to operate a car, why does the measure specifically call out fuel? Doesn't that
Because it specifically calls out fuel, a number of them.
Doesn't it render fuel superfluous?
I don't think so.
The reference to fuel.
I don't think it renders the reference to fuel superfluous, Your Honor. I think it's when you're talking about, first of all, it's called out perfectly, and that's a purchase of a commodity that we talked about. Here we're talking about rental, which is operation, registration, or use, and I think fuel is called out separately, specifically to bring it within that context. Rental of a vehicle is not the same thing at all. What am I not understanding about your question, Judge Johnson?
I'm trying to find a limiting principle to the term relating to registration, operation, or use. And what I understand you to be saying is it's relating to encompasses a tax on something that you must pay to operate, or that's implicated in the operation of a car. But fuel is implicated in the operation of a car, so I don't know why the measure would specifically call out fuel.
Well, it also calls out exemptions, and I think that the calling out of fuel is, something that we see mirrored in other provisions as well.
Yeah.
And particularly talking about the notion of gross receipts, which brings it into that transaction privilege tax sort of notion.
What other cases around the country, other than the 3 Ohio cases, would you say interpret an anti-diversion statute, a measure like ours, that includes relating to encompass anything like a rental car surcharge?
I don't think that there are other cases that interpret relating to when it comes to a rental car surcharge in that instance.
Any other cases other than the Ohio cases that interpret relating to in an anti-diversion measure?
No, those are the cases that we have, Your Honor. I would be happy to point the court if I could. We have, in terms of the Ohio cases, I would want to point out that there is well, it may be true that some, in terms of getting the certificates in Ohio trucking, that abstract of records. What the court did in that case, which I think is important when looking at that case, is the court said that it found that the task of getting these abstracts, and we pointed out these abstracts are big. I mean, apparently insurance companies, fraud companies, and all this stuff are getting these abstracts. That the court said that is more related to, right? It's more related to the process of getting this certification, and not related to operating a vehicle. And I think number one, I don't think that that's the standard. The Constitution says related to, and this is a plain language case, plain meaning case. But I also think that limits that case because the court is applying a standard that says this is more related to this other thing, this process of getting these documents, whereas the rental of a car is not.
So is it okay to say more related to? Is that the test?
Your Honor, I hesitate to say that's the test because that's not what the Constitution says, but you're looking for a limiting principle here, and the one example which they rely on might have arguably a limiting principle in it, in the sense that they're talking about, is this more related to one thing versus another? We wouldn't urge you to adopt that test. I think it's an explanation for what the court was doing there. The notion that you don't need it in order to drive seems to me that this is not a tax that everyone has to pay, or a fee that everyone has to pay in order to drive or operate. It seems to me that that's a much more narrow construction of what that case holds. I don't think the case holds that. I think what the case says
So
is,
under your construction of the term, would it encompass receipts at an auto repair shop? Revenues at an auto repair shop?
no, I would not think that it would include revenues in an auto repair shop.
You don't need to repair your car in order to drive? Isn't that related to driving a car?
Obviously, there's going to have to be some limiting principle, but no, I would not say that is I think that stretches the plain language of related to further than the Constitution would allow.
So, sorry to keep hammering on this.
No, it's fine, Your Honor.
Having conceded that there should be a limiting principle, what is it, in your view?
We've got language that says, is it connected to, we got a dictionary definition, so we'll just talk about, is it connected to? How is it connected to? And in this instance, we're talking about a connection to the use of our streets and highways. And this is specifically what is happening in a rental car situation, which I think distinguishes it from some other contexts in which you might say, well, yeah, I can use a causal chain to get to related to. I think it would have to have some sort of amount of reasonability, which is a common statutory construction. However, in this instance, I don't think it's a difficult process because this is a tax that is paid when you rent a car and you're immediately going out and hitting the streets. I think it's entirely consistent with what the anti-diversion provision is designed to do.
What about auto tire sales? Did that fall within the measure?
I would not think that auto tire sales would necessarily fall within that measure, but again, you're talking, and of course not all auto tires are immediately put to use on the road, and we're looking at a provision that is specifically targeted at, and again, I understand that the court is trying to find where to draw the line.
We need to do.
No, I understand that, Your Honor. And in this instance, I think what is easy to do is to say this is within that line.
Well, what about the language in the pamphlet, though, that assured voters that the constitutional amendment wasn't going to change anything, and there was already a business privilege tax on the rental of cars that, of course, wasn't being put into the highway fund?
I don't know that language, I don't know how much weight the court can give to that language. Again, we're now at an interpretive point where we've left plain language of the, plain language, and we're moving on to other interpretations. I don't know that assurance can be given any dramatic amount of weight. This is a publicity pamphlet. As we pointed out, there were a number of comments in that publicity pamphlet that, they talk about us being a baby state, and they make references to other states that have these provisions, and they talk about the purpose, which is to make sure that highway funds are available. That highway funds aren't going to get diverted. And they say, we're not diverting them right now, but we don't know that that's accurate. That's a opinion of the publicity pamphlet, committee that wrote it. And we have, I will recognize that we'll talk about it perhaps in the next section, but we have this dueling publicity pamphlets. Your Honor,
Don't they call that having your cake and eating it too?
They do. These guys really want to have their cake and eat it too.
I think there's enough cake to go around.
But Your Honor, I think that I wouldn't take that legislative history as indicating this provision. And we often have provisions that sit for a long time. We cited the Phelps versus Firebird Raceway case, which was, had a constitutional provision that had been around for 100 years. And I am confident that numerous judges there have been judgments, there have been all sorts of things that had come out where assumption of the risk was not submitted to the jury. It had never been challenged. And that doesn't mean that wasn't what the Constitution meant, and that's what the Supreme Court found, that no, the Constitution means what it says, and completely disregarded legislative history, a legislative history that was, in the Court of Appeals opinion, laid out in some depth, and the Supreme Court said, we're not going to get there because we're just going to read the plain language. I would like to talk for I would like to mention for 1 minute this parade of horribles, this absurd results. And I'd like to point out something that again, narrowly focused on this case. There's a reference in the briefing to this case. There's a $150 million refund, and Mr. Hudson's introduction is about plaintiffs who are stretching the Constitution to try and get some sort of windfall. But I want to let you know that that's not supported by the record. We don't know what the amount of the refund is going to be in this case. And we'll talk about, I know we're going to talk about refund. We don't know about what the amount of the refund in this case, but we estimate it to be significantly less than 150. And in fact, only the Department of Revenue knows which members of the class have actually opted out. And so we can't know the number until we understand who's opted out and we get to that piece. And I want to point out one other thing, that particularly in this case, when we're talking about this particular provision, there's a legislative fix for this provision when it comes to the HERF, which is just to simply go to the legislature. The legislature can change this. It's not voter protection. It's not subject to voter protection. The legislature could simply direct these funds to go to the HERF, and then it could direct an equal amount to come from the general fund to fund all of the tourism provisions that are animated under this statute. So I just want to point out that the parade of horribles here, I think, is overblown, and it's very much cart before the horse, because we don't even know what the amount of the refund is in this case or any of the others.
Thank you, Mr. Young.
I've got a question that
Yes.
I hope someone can answer. It's a real easy one. What happened to enterprise leasing? Did it opt out or not? And maybe someone can answer that at some point. It did opt out?
Yeah, that's what we understand.
Okay.
All right. Thank you.
Thank you. Rebuttal.
Yes. It's,
If you want to. No, I will rebut myself, but I'll let you go.
Your Honor, just a few a few very quick points. One, on the plain language issue, we are talking about a constitutional provision. The Arizona Supreme Court has said over and over again, you've got to look at first purpose, context matters. We cited on pages 10 and 11 of our reply brief a bunch of cases, including from the United States Supreme Court and Justice Scalia saying related to is a paradigm example, and we need to do that. Second, no consumer or business ever pays the asset tax to use a vehicle. And what I heard Mr. Young say is that when somebody goes to rent a car that they pay this tax. That's not true. The tax is not paid by the renter, and it's not even paid at the time the car rental transaction occurs. It's paid 30 days later. And the reason, and again, that just makes my point, which it has no connection to vehicle use. No one, neither the business nor consumer, pays that tax to use the vehicle. They have no limiting principle. The examples we've given of the sale and standard auto lease fit squarely within their theory. There is simply no meaningful distinction between a short-term auto lease, renting a car renting a BMW for 3 days, or renting a BMW for 3 years. There's no meaningful distinction. Fourth, this court, we of course invite it to do so, and I think we've given the court what I call a plain language and common sense interpretation of the statute. But to decide this case, the court doesn't actually need to define related to. The Ohio Supreme Court didn't. All it actually needs to do to decide this case is conclude that their interpretation goes too far. It's not the right one, and the asset tax is not subject to Section 14. Lastly, we heard Mr. Young invite a legislative fix. I would submit that if this case goes to the voters, the publicity pamphlet will say, our Court of Appeals messed up. Don't mess up. We ask the court to reverse and remand for entry of judgment in the defendant's favor on the state constitutional issue.
Thank you for that vote of confidence. All right. Thank you, counsel. We'll proceed now with the second issue dealing with the Dormant Commerce Clause. Mr. Young, that will be you.
That is me.
Very good.
Taylor Young for Saban on the Dormant Commerce Clause. The question in this case is really whether the car rental surcharge is going to be subject to strict scrutiny as a discriminatory tax, or if it's subject to a balancing test. You can see that from the briefing. The parties have focused, I think, extensively on what test should apply.
You both have conceded that it needs, if strict scrutiny doesn't apply, then the game's over.
Yeah, if strict scrutiny applies, we win. I think it's been conceded. And if we're in a more of a balancing test, the evidence is a little weaker. It is a summary judgment standard, but we think that this case really turns on which test applies.
Well, you're not really arguing that it's discriminatory on its face, are you?
We're arguing that it has a discriminatory intent, which has been expressed and can be seen. What the Supreme Court, the United States Supreme Court, has done is has said numerous times that a statute has discussed facial discrimination in a context where the intent is clear. And that's really what this gets down to is this what we call an effects case, or is this a intent and purpose case? And I think one of the things that is a good framework to think about this, and it's a came up in our briefing, is if the statute had said explicitly that in-state residents don't have to pay this car rental surcharge, out-of-state residents do, it's conceded that that would be facially discriminatory and would put it straight into strict scrutiny. In this case, what we have is a statute that says that car rental surcharge applies and then has a carve-out for those who are doing replacement vehicles. And the legislative history makes it clear that that carve-out was intended to do exactly what the Supreme Court has said that you can't do, which is intentionally discriminate against interstate commerce. And that's what's happened here.
Well, you're not contending, are you, that it is that the surcharge impermissibly or has impermissible discriminatory effects, are you, that it affects similarly situated out-of-state residents and in-state residents differently?
It has a design.
Well, that's kind of purpose.
I hear you.
Let's talk about
I hear you. That's fine.
Boxes. Is it?
That's fine. Now, we're not saying that there is a effect, a specific effect. Let me understand your question again. Similarly situated.
In-staters and out-of-staters. The surcharge treats all call renters the same, whether you're from in-state or out-of-state.
It treats all car rentals the same, whether you're from in-state or out-of-state, or in-county or out-of-county.
Yeah.
All the cases talk about states, so that's the language you use. But it does not have the temporary replacement vehicle provision. While it's conceptually true that you could see somebody doing a temporary replacement vehicle who's from out of state, that's a theoretical possibility. It's clearly not what that provision is designed to do. That provision is designed to carve out in-state residents and give them a lower surcharge.
But even that tax applies the same, whether you're in-county, out-of-county, in-state, out-of-state.
But it applies the same in the sense that we're not going to check your driver's license to see whether or not you're entitled to the temporary replacement vehicle. It just has the practical effect of being a proxy, which is, as the court has read all these Commerce Clause cases, I mean, legislatures work hard to try and find a way to discriminate in a way that appears as neutral as possible, and that's, in this instance, I think that's what we have. We have and we've pointed the court to ample evidence that what this was designed to do was to target out-of-staters for this tax, and that's the absolute intent. And there can be little doubt about it, particularly given we're looking at a summary judgment record. Our burden was just simply to show that it's a discriminatory tax. And I think we've met that burden by showing that there was an intent here to target out-of-staters, to make out-of-staters pay. And the reason why they wanted to make out-of-staters pay is because out-of-staters don't have a voice in this political process. They're not represented. They're not engaged in this process. And as the court's aware, if you can look at the publicity pamphlet, and look at the website from the TSA, they bragged that their whole strategy was to discriminate against out-of-staters.
So in this context, you want us to find that the publicity pamphlet is reliable information that created a genuine issue of material fact, but in your earlier argument, you basically invited us to disregard it.
I did not invite the court to disregard the publicity pamphlet, except for the fact that it was a plain language argument, and I don't think we're in a plain language scenario here. So that's a distinction. I think it's an important distinction. And in Commerce Clause cases, the court has had no problem in the past looking at these types of materials to determine whether or not there's a discriminatory intent. And I think it's important because this is a constitutional provision. The reason why we have this presumption, basically per se invalid, unless you can show that there's no other way to do it, is because the Constitution prohibits this type of discrimination. And here we have a specific targeting of interstate commerce. We have a specific targeting of out-of-staters in order to accomplish this goal.
The United States Supreme Court has never invalidated a state tax based on a discriminatory purpose alone, has it? I mean, I didn't find any. So let's just assume that's the case.
I think Bacchus is the example, though. I'm sorry.
That statute expressly referred to wine manufactured in Hawaii.
But that's not what the court has said.
In Amaretto,
And subsequent cases and numerous scholarly articles. And by the way, Your Honor, we the other side took us to task when we were trying to hide it. We cited the language. We dug it up to try and see what that statute looked like because the Supreme Court didn't discuss it in its opinion, but it did characterize it and has subsequently characterized it. And there shouldn't be a reason not to invalidate a statute based on intent alone. When you have a discriminatory intent, that then just switches the burden to the other side.
That statute was obviously aimed, whether you look at the face of it or whether you look at the intent of it, it was obviously aimed at protecting in-state winemakers. There's some circuit court cases that have similarly invalidated. South Dakota is like a hotbed of protectionism. Farms, waste, a lot of protectionist cases there. But what is a discriminatory purpose? I mean, that's what I'm trying to get at. Here you say there's a discriminatory purpose because it's clear that this surcharge targeted tourists. But wasn't the purpose of the surcharge to build facilities that would attract the tourists, would encourage interstate commerce?
Well, the purpose of the statute as expressed in the publicity pamphlet and the governor's Plan B report was to preserve the tourism industry. It was seen as this grand threat that our tourism industry was going to die if the Cardinals or the NFL left. That these were the things that we needed in order to preserve. Couldn't have Super Bowl, couldn't have all those things. And that's not unusual in protectionist measures, right? There's milk industry is dying on the vine here in Massachusetts.
What is tourism? It's people coming across state lines into Arizona.
Yes, Your Honor, but in this instance, what you're doing is targeting that I think is lumping in this provision that targets specifically these out-of-state consumers. It targets them to bear the brunt of the cost of this thing.
Facilities we're building so that they can come.
Well, but they don't necessarily. I mean, Your Honor, there are specific purposes in this statute, but people don't ask when you come in, are you planning on going to a Cardinals game or using a multi-purpose facility? So the fact that there may be a tourism element to the purpose of preserving this industry doesn't make it not protectionist. And I would also point to the court that the burden shifting is really important here. We pointed out discrimination, which is targeting of out-of-state consumers, and the court's been very clear, the Supreme Court's been very clear, that and the Ninth Circuit has talked about how that not being invested in the political process is one of the reasons why you have a dormant commerce clause, to protect people who aren't don't have a voice in the political process. And here, those tourists are being targeted for that. Now, whether that's rational or whether how much that dissuades doesn't matter, because what the court has told us is that once you have discrimination, then it doesn't matter what the degree of discrimination is. It doesn't matter what how wide the effects are. Once we know that it's discrimination, we're shifting the burden over to the state to show that this doesn't have a protectionist purpose.
What's the case that says that?
Your Honor, hold on 1 second. I'll pull it up. Your Honor, it's in footnote 28 of our opening brief.
Okay, I'll find it there. Thanks.
Okay. Staying on the issue of, you're sort of presuming discrimination in your argument, but hasn't the Supreme Court in its jurisprudence indicated pretty strongly that in this situation, the overwhelming burden of the tax can fall on out-of-state residents and still survive this type of challenge?
The fact that a burden falls on out-of-state residents doesn't mean that it is intentionally discriminatory. I mean, that's the difference.
Or even that those out-of-state visitors don't get to use or don't use the very service or amenity that is being touted.
But, Your Honor, again, I think that's a step removed. What we're talking about here is a legislature who specifically said, we are targeting these people in order to do this thing. And that is an expression of discrimination rather than a neutral statute that has the effect of having the burden go more on one group of people, out-of-state people. That's different. When you have just an effects case, we go into a balancing scenario. But here we have clear expressions of discrimination. And again, Your Honor, I guess I might respond this way. If in fact it's okay for the burden to fall on out-of-staters, which is said, then why in a facial situation, why in a statute where it's said out-of-staters pay, in-staters don't, that's facially discriminatory. We go straight into the strict scrutiny test. So what we're talking about here is expressions of intent. You can find that through facial. You can also find it through expressions of intent that show that this is what they were trying to do, rather than doing something that's neutral and has the effect of actually impacting people from out of state.
Would it be permissible to enact a fee, a tax on ticket sales to national championship games and Super Bowls and Final Fours to pay for those facilities? I'm just wondering, would that fly in the face of the dormant commerce clause? Because we know that most people who go to the Super Bowl when it is here are not Arizonans. Most people who go to the Final Fours are not Arizonans, and so forth.
So I guess the difference is, are you presuming that we also have all of these expressions of intent?
Yes.
Then no.
So
if you don't have those expressions of intent, then we have to look at a balancing test, right? So I think that's the I don't want to say easy answer, maybe simple, not easy.
So if the NCAA and the NFL form a consortium and come to Arizona and say, we really want to play our end of season games in Arizona, it's so beautiful. Will you build a facility and our ticket holders will pay for those facilities? And the legislature says, well, we will build it, but only if you will pay for it. Only if we can charge ticket holders for that. That would fly in the face of the Dormant Commerce Clause?
That would fly in the face of the Dormant Commerce Clause unless it had an expression of intent that we are expressly targeting out-of-staters, that this is, the whole point of this is to look at consumers who are out of state and make them bear the brunt. And again, these political expressions in the publicity pamphlet, I mean, this is not hard to see what the intent is here. And that specific intent is a discriminatory intent. And that puts it in a strict scrutiny. If they said, show your, we're going to create a statute that says, and I'm well over time here, I'm trying to answer your question.
I asked the question.
If you had the scenario you're talking about with ticket sales, and it facially said, out-of-staters pay this, in-staters pay that.
Not my hypo.
I understand.
Yeah.
But that would be facially discriminatory. If you then have the same statute with 12 different expressions of intent that says our intent is to do this, and in fact it's the only way we're going to get this passed.
Yeah, Arizonans don't want to pay for it.
Right, Arizonans don't want to pay for it. That is discriminatory, and that puts you in the strict scrutiny test. I'm well out of time. I'm happy to continue answering questions.
I think we'll move on. Thank you. And we'll see if
Can I get a couple minutes for rebuttal?
we'll consider it, your request.
Thank you, Your Honor.
Mr. Berg.
May it please the Court. Timothy Berg of Fenimore Craig on behalf of the Tourism and Sports Authority. I want to start with the last discussion you had with Mr. Young and think about what he's telling you. What he's telling you is the state of Arizona could pass a tax which does exactly what this tax does. And if no one said anything about tourists in the publicity pamphlet, in the legislative history, when they set up the task force, that would be that would not be a discriminatory statute. It wouldn't be subject to strict scrutiny. But if they do, it is. What that means is that you can have exactly the same tax with exactly the same burden or lack of burden on interstate commerce and have it turn on what, in his first argument, he suggested was sort of worthless language in a publicity pamphlet. That can't be what the law is. Mr. Young concedes that the burden is on them to show that the tax was discriminatory and that if they can't do that, strict scrutiny doesn't apply. This tax isn't discriminatory. First, who's taxed? Rental car companies are the taxed entities here, and in-state and out-of-state headquartered rental car companies are treated the same. Doesn't matter if you're Saban or if you're Hertz or if you're Avis or, I guess, Enterprise, who's opted out, but it's still probably paid the tax. The tax is the same. Second, the tax applies, the tax is then passed on to the rental car customers by the rental car companies, and that's their decision to do it. They could pay the tax and not pass it on to their customers and raise the price of their cars, or simply eat the tax as a cost of doing business. But if they do, the way it's applied to the transactions isn't based on where the customer's from. Tim Berg doesn't pay one rate for a rental car because he lives in Arizona, and my brother-in-law, Bill Robinson, pay a different rate because he lives in New Jersey. That's not how this tax works. I pay a rate depending on what I'm going to use the car for. If I, Tim Berg, as a citizen of Arizona, go to a rental car company and say, I've got family in town. They're visiting for the holidays. I need a van. My four-door sedan won't carry enough relatives. Then I rent a van and I pay the higher surcharge, just like someone would coming in from out of state. My brother-in-law coming in from out of state and renting the van instead of me. If I have to go get a replacement car, I pay that rate. My brother-in-law's car dies and he has to get a replacement car while he's here in Arizona, and he could be here for months. It doesn't have to be a short trip. Then he would pay the lower surcharge rate. And what makes this even more interesting and in some ways incredible is nobody has ever paid the differential surcharge. What the record reflects in this case is that the rental car companies have charged everybody the same. There has been no discrimination here. And they cannot cite to you a Supreme Court case that has invalidated a state tax on the grounds of purpose alone, or that has invalidated a state tax where the purpose was to discriminate and the tax did not, in fact, discriminate. That's really all this case is about and all you need know.
You're saying that demonstrated effect is more critical than potential stated purpose, whether it's in a publicity pamphlet or otherwise.
Absolutely, Your Honor. I think, first of all, there has to be some effect. If nothing discriminates, there's nothing to declare invalid. I mean, think about this for a minute. If you take this and apply it to another area of law, what their argument is essentially is that if I intend to libel or slander you, and I say something that is true, so that I would have a defense, but I don't. What I say is true, I'm nonetheless liable because I intended to do it. That's not how the law works here or anywhere else.
Although I've thought about that, and I'm perplexed about how that works out in this case, because, as you say, the members of the class are not charging differential rates, but the surcharge allows them to do that. So I'm not sure it's as easy as that, because tomorrow they could start doing that, and then we'd be back here.
Fair enough, Your Honor. Our position is that the replacement car exemption isn't discriminatory, even if they were charging.
Okay.
I think the fact that they're not charging it makes it easier for you because there is, in fact, no discrimination here, and so there's nothing to enjoin, there's nothing to invalidate. But certainly, we also take the position that the replacement car surcharges is also not discriminatory for the exact reason I described to you. My brother-in-law and I, he's from New Jersey, I'm from here, we pay the same, depending not on where we're from, but on the type of transaction we enter into, a replacement car transaction or another car rental.
What do the cases teach us about what it means to have a discriminatory purpose? Is it enough
I think what the cases
to enact a piece of legislation that you know is going to fall on out-of-staters?
Well, first, I think what it teaches you is that purpose alone isn't enough. We cited a number of cases in our brief, including Judge Campbell's decision in the Puppies and Love case, including the, I'm going to butcher Gwadowski, or however you would say it, from the First Circuit, the Walmart case versus City of Turlock from California, which say purpose alone can't be enough. It just can't be. You've got to, in fact, have some discrimination in order for it to be. If a legislature, there are any number of quotes in our brief, if a legislature intends to do something discriminatory and in fact doesn't do it, there's no interference with commerce. There is no usurpation of Congress's power to regulate commerce. There is no injury that the Constitution was intended to prevent.
But there are some cases, the South Dakota cases and another one, I can't remember, do invalidate taxes based on evidence alone of discriminatory purpose. But what
yes, Your Honor,
does that mean? A protectionist purpose? Does that mean a protectionist purpose? Does that mean a purpose that interferes with interstate commerce? What does that mean?
I think that's what it means. I guess I have two responses to you. One, I think if you look at those cases, in fact, there's a discriminatory effect, whether the court decided there was or not. Two, I do think your point is something important. The Edison, Montana case teaches you that it is perfectly valid to have a tax, the incidence of which is primarily on out-of-state residents. In that case, 90% of the tax was paid ultimately by utility customers in other states. I don't think if it's valid to have that kind of statute, it can be invalid to have the purpose of the statute having that effect. What their argument pushes you to is if a legislature is either negligent enough or uninformed enough to pass a tax that bears mostly on out-of-state people, it's okay. But if they know that's what the tax is going to be and they intend that's what the tax is going to be, it isn't. I think the purpose that they're talking about is what you're talking about, Your Honor, protectionism. The example Mr. Hudson used in his brief I thought was a good one. If Arizona adopted a tax on citrus fruit brought into Arizona to benefit the Arizona citrus industry at the expense of California and Florida. That's a classic protectionist tariff. Now, I think as a practical matter, if there was a discriminatory purpose, there would be a discriminatory effect because, again, legislatures, we hope, don't pass statutes that don't do what they want them to do. And if they do, I'm not sure they've done anything wrong. That's the problem with purpose here. The other point here is that the purpose of the statute is to encourage tourism. And that's a valid purpose, and we're using the money to encourage tourism to benefit the tourists who are coming in, as the court's pointed out. There simply isn't, one, there isn't an invalid purpose here, and two, purpose by itself can't matter. You've got to have some discrimination, and if they can't prove some discrimination, then we never get to the point of shifting the burden. There is no strict scrutiny, and on a balancing test, we win. The case is over.
Are there other cases that dealing with purpose and maybe purpose plus effects that are measures like this that aren't overtly protectionist?
Now, if you look at most of the cases, they are overtly protectionist. They either are protectionist. My example, the example of keeping waste out of South Dakota, the example of taxing liquor that isn't produced in the state in a way differently than you would the native produced. That's the Bacchus case. Most of them are classic protectionist cases. The cases that tend not to be that tend to find that there isn't a discriminatory effect or purpose and uphold it. If you look at Commonwealth Edison, there's really no difference between the taxpayer and the taxpayer if you give them everything that they haven't proved yet, because we know that, for example, the class members predominantly rent to in-state people, not out-of-state people. Some of the national companies represent more out-of-state people. But assume for a moment that it falls more on out-of-state people. What Edison tells you is there's nothing wrong with that. And if there's nothing wrong with that, there can't be something wrong with adopting a statute which has that effect and is intended to have that effect. You end up in a world of you end up walking through the looking glass at some point and saying it doesn't matter what a statute does. It doesn't matter if commerce is affected. It doesn't matter if the statute on its face says it discriminates. What matters is, can I find a statement or two from someone in the legislative process that says it's intended to be discriminatory? And we cite you a lot of cases where courts go through that information and disregard it. But even if they don't, you can't have a Commerce Clause claim with strict scrutiny without discrimination, and there's no discrimination here, either because of the way the statute's been applied or because of the way the statute's been written.
Here's the thing, though. Mr. Young would say, what really, speaking of looking glass, what really is the difference between a statute that on its face says out-of-staters pay one, in-staters pay a different rate, and a very ingeniously contrived statute that has 99% of the burden falling on out-of-staters versus 1% in. Now, Westland Creamery,
Yes.
97% of the tax fell on out-of-state milk producers, I guess, and the court said that would be fine except for the rebate. So, but what's the logic there?
Well, the logic is, I think, first, Your Honor, is if the statute on its face says we're going to charge people from California $100 and people from Arizona $50, I think the court can assume that that's what happens. That makes the statute invalid. On its face, the statute tells you to do something that you can't do. If the legislature intends to do something but doesn't pass a facial statute that tells you to do something wrong, and in fact the statute doesn't do anything wrong, doesn't discriminate, then the fact that they had a bad intent doesn't make it unconstitutional. And that's why you can't find a case from the U.S. Supreme Court invalidating something on purpose alone. It's why the cases we've cited, the Ninth Circuit, District Court here in Arizona, District Courts in California State Courts, have all said purpose alone can't be enough. You've got to have some actual discrimination. If the court has no more questions, thank you very much.
Thank you, Mr. Berg. Mr. Young, we're going to give you 3 minutes. Okay, Tom, you need to set 3 minutes.
3.
Oh, 3?
Yeah.
We're going off schedule.
Very good, thanks.
I'm glad the court brought up Wesleyan Creamery because that case, I think, is important to understand. Mr. Berg spent a lot of time saying it doesn't, in fact, discriminate, and it has no discriminatory effect. Well, first of all, there is evidence in the record that the tax was paid for a while, and then a choice was made, basically, that it was not worth the administrative headache of charging a differential rate. And so that is in the record. It isn't the case that it is purely something that has never been implemented. But it also is really problematic, is that if you have a statute that is intended to be discriminatory and has a discriminatory structure to it, and yet the private actors who are supposed to be incentivized refuse to be incentivized, they take it upon themselves not to discriminate, that immunizes the statute against constitutional attack. I don't think that can be the case.
Well, what's your best case for the proposition that a tax like this, that is not protectionist, it may be invalidated based on a discriminatory purpose alone?
Well, it's preservationist, and I think Wesleyan Creamery is important to look at because what you have here, what you have in Wesleyan Creamery is this attempt to preserve this industry, right? Because they have this differential rate. It's cheaper out of state, so we're going to create this rebate structure in order to preserve the industry. It's a facially neutral statute in the sense that it doesn't actually specifically say out-of-staters pay this, in-staters pay that, but the court looks at the purpose and then the court presumes effects. There's nothing in Wesleyan Creamery that says there was evidence of actual effect. There's no evidence in that case.
But only to the in-state producers. They didn't go to out-of-state producers. Isn't that an effect?
Well, but there's no actual evidence that they showed that those rebates were actually happening or how much those rebates were being paid. And so it's presumed. In fact, I think, if I recall, I have to go back and look at it, but I think that this was early enough on this in the context of the statute that it was really a presumption rather than an actual finding that this thing was happening. Now, it's the design of the statute. Same thing with the car rental surcharge. It's the design of the statute. Just because we can look at instances where where the industry has decided the administrative headache and risk is not enough to be incentivized to discriminate the way the legislature intended, doesn't excuse that discrimination.
All right. Thank you. All right, we'll move to the retroactivity and refund issue. Each side will have 10 minutes on this.
Good morning, Your Honors. May it please the Court. My name is Scott Claus. I represent ASTA. I'd like to reserve 3 minutes for rebuttal. I'll be addressing the argument why today, if the court orders any relief for the plaintiff class, it must do so prospectively only, employing the feign factors that have been employed uniformly by myriad courts for more than 25 years. Those factors must be balanced by the court, and the court must inquire whether a decision today establishes a new legal precedent or was not clearly foreshadowed by existing precedent, whether retroactive application would further the operation or purpose of the rule, and whether retroactive application would produce inequitable results. And to really show in stark relief why any adverse ruling against my client should be given prospective-only application, I'm going to address those factors in reversed order. First, the equity factor. The plaintiff class requests what it calls a refund. However, from a most fundamental linguistic perspective, logically and legally, a refund would have required the plaintiffs to have suffered some type of pecuniary loss. But in this case, the evidentiary record and the historical record is clear and unrefuted. The entities comprising the class, despite what Mr. Young just told this court, admitted in interrogatories at index of record 161 and 122 that they passed along the tax that they paid, not that a single car renter paid. The tax that they paid, they passed along at a uniform and higher rate to every single renter of every single vehicle, irrespective of the residence of the renter or the duration of the rental. Accordingly, there is no refund that could make whole the plaintiffs because they have not suffered actual harm. In stark contrast, and this is what separates this case from the cases upon which the plaintiff class relies, ASTA would suffer serious harm if an adverse decision was given retroactive effect, because, again, the record is clear and uncontested that the taxes collected pursuant to the subject statute are the sources of repayment for more than $200 million in revenue bonds issued and sold to purchasers. Those taxes, paid by the rental car companies, not by a single car renter, serve as a substantial source of repayment for the senior bond debt and the only source of repayment for the subordinate bond debt.
I've got a question.
Yes. So,
on your first premise.
Yes.
How I mean, I get that. The entities, the car rental companies passed along the fees, but how is that different from any other tax on business? And what this tells me is, but for the surcharge, maybe the car rental company should have been charging more money in the first place. And they could have had more net profits if they had chosen to. But in reality, all businesses pass all their taxes on to their customers if they can.
If they can, Your Honor.
And they do because they're in business. So
what's of critical importance today is that the feign factors require the court to balance the equity of a retroactive application of its decision, and in this case, the equities strongly tip the scale in favor of ASTA because the car rental companies would benefit by receiving a windfall of a tax for which they've already been repaid by their customers. Yet, ASTA would be deprived of a significant source of funding with no ability statutorily or constitutionally to replenish that. So under the equity factor, Your Honor, it's important for the court to consider the reality of the fact and the admissions by the plaintiff class, because that tips the scale on that factor in favor of a prospective-only application.
What about the suggestion that having achieved, at least in principle, a refund, the car companies would be subject to possible claims by their customers?
Well, Your Honor, that's sheer speculation and conjecture. There is, and again, Your Honor, we're here on a ruling on a motion for summary judgment. They had an evidentiary burden that they did not meet and did not attempt to meet by showing any evidence that sheer speculation and conjecture was made manifest in admissible evidence. And so I don't think the court should entertain that sheer speculation in trying to balance the equity factor against ASTA and in favor of in favor of the car rental class. The purpose factor is the second factor that has to be balanced. And remember, the tax court determination was not that the levy or collection of the tax was impermissible or constitutionally prescribed. It was the way in which the money was spent that was the linchpin of the tax court's decision.
So then what should happen to the money?
Well, that's exactly right, Your Honor. The purpose to be furthered by the tax court's decision, which certainly would not further the purpose articulated and embodied in Article 9, Section 14, which is to provide funding for highways. Not a penny of any refund to the plaintiff's class members would go to benefit a single road or highway in the state of Arizona. And so the purpose for which a ruling was made would not be furthered one jot by giving it a decision retroactive application.
Well, did Judge Whitten err by not directing that the money be put to the highway fund?
So, I'm sorry, Your Honor.
Shouldn't under that rationale, shouldn't Judge Whitten have ordered that the money be put back into the highway fund where it belongs under Section 14?
Well, Your Honor, again, I don't think that's the case. Assuming, of course, that the court found that the spending of the revenue violated Article 9, Section 14, the money has already been spent. So I'm not even sure that that's a permissible remedy. But the remedy that was crafted by the tax court here certainly doesn't further the purpose, and so that balance, that weight goes in favor of ASTA. Finally, Your Honor, the existing precedent question, and I don't know, have you already subtracted the 3 minutes for rebuttal? I didn't look at the clock.
No.
Okay. The purpose, Your Honor, or the existing precedent. This statute had already survived two challenges in Long versus Napolitano and Carball. In Carball, the seminal question was, what was the nature of the tax? It was a tax on the business of leasing vehicles. Because it was a tax on the business of leasing vehicles, the car renter had no standing to pursue a remedy. A decision out of this court that because the business of leasing vehicles conferred no standing on a car renter certainly did not foreshadow the construction of the phrase in the business of leasing rental cars in 5839 as a tax that could be construed as being related to highway purposes under Article 9, Section 14. I'm running out of time, Your Honor. Let me just end and save some time by rebuttal by addressing McKesson. The tax court erred grievously by determining that it was required to follow McKesson. There is 80 years of United States Supreme Court precedent that tells us that the tax court was wrong. In American Trucking, a case decided on the very same day as McKesson, it relied upon Sunburst Oil that stated explicitly, quote, when questions of state law are at issue, state courts generally have the authority to determine the retroactivity of their own decisions.
Would McKesson apply, though, if the surcharge needs to be invalidated under the Dormant Commerce Clause?
It would not, Your Honor, because McKesson applies to a very narrow field of taxes and cases where the tax discriminates. And Your Honor, you hit on this point exactly when analyzing the Commerce Clause issue with Mr. Berg and Mr. Young. McKesson deals only with a narrow class of taxes that discriminate against two different sets of taxpayers and favor an in-state taxpayer against an out-of-state competitor. In this case, the taxpayer is the car rental company, and the tax rate applies uniformly whether the car rental company is an Arizona domiciled company or a Florida domiciled company. And so McKesson would not require retroactive application. And even if McKesson applied, Your Honor, it would not require a refund because McKesson stated explicitly that states must be given flexibility in dealing with a case in which taxes are invalidated for Commerce Clause purposes. And I would like to reserve the 2 seconds I have left for a rebuttal, Your Honor. Thank you.
All right, thank you, counsel.
May it please the Court, Taylor Young for Saban and the class on the refund question. We think that McKesson is applicable in this situation, and it's the notion that you have a illegal tax that was collected. The notion that that one has to pay the tax in order to be able to challenge the tax has fundamental due process concerns which should apply in this situation. The prejudice. Let me talk about Carble real quick. One of the reasons why we noted that we could be subject to claims by customers is because Carble told us that the customers don't have standing to assert these claims. We have standing to assert these claims. But that does not mean that when a refund comes back to us, it's a windfall for the rental car companies, because there's a great potential that the customers themselves could come after the customers. So come after the companies. So the equities in that situation don't tip so dramatically in favor of AZSTA as they would have the court believe. And the history that the other side points to in terms of FAIN and the adoption and use of FAIN, one of the things that we point to the court to in our reply brief is that I apologize, Your Honor, Your Honors, is that some of the cases that have been cited for this notion that it's uniformly applied don't necessarily anticipate or don't involve a discussion of McKesson at all. So the implication there is that the court has made some decision to apply FAIN when in fact it may, if it wasn't an issue in the case, doesn't mean that there was a decision made there.
What about the argument Mr. Klaus makes that ASTA has already been paying the bonds using this money? It's not as if it has those funds in a bank account.
Well, that issue I think is going to end up being between ASTA and the Department of Revenue, frankly.
Do you think the state has those monies in a bank account?
Your Honor, it's when you have an illegal tax that has been collected, I mean, the state wouldn't have those monies in a bank account necessarily in another circumstance where you had illegal tax collected. And that's really the fundamental issue here, is you have an illegal tax, and the notion that, particularly since you have to pay it in order to challenge it, the notion that you can simply just sit on or characterize this as a windfall when there's been an illegal tax, I think gives lie to the Constitution, or gives lie to the protections in the Constitution. If the court has anything further, I'm happy to answer any questions.
No, thank you.
Thank you, Your Honor.
Mr. Claus, we're going to give you a minute and a half, since Mr. Young has generously given up some time.
I can't have Mr. Young 6 minutes. Thank you, Your Honors. I counted, Mr. Young used the phrase illegal tax 7 times in his 4-minute argument. That is fundamentally incorrect. This is not an illegal tax. It was not found by the tax court to be an illegal tax. The only proscribed activity found by the tax court that brings it within the ambit of Article 9, Section 14 is the manner in which the funds were expended. And we know from the Arizona Supreme Court in Wilderness World, 1995, post-McKesson. We know from this court's decision in Copper Hills, 2007, post-McKesson, that The fact that a tax is found to be inappropriate does not render it incapable of having the Fane factors applied, because the Supreme Court in Wilderness World and this court in Copper Hills applied the Fane balancing factors. The tax court and the plaintiffs ignored the case that was decided on the very same day as McKesson, American Trucking. American Trucking stands for the clear proposition that McKesson applied to a narrow class of cases in which a tax was found to discriminate against out-of-state competitors to provide a competitive advantage to in-state taxpayers. Again, I will keep saying it, the tax was not borne by out-of-staters, it was borne by car rental companies irrespective of domicile. And finally, Your Honor, American Trucking recapitulated Sunburst Oil's proposition from 80 years hence that when state law is at issue, the state courts determine retroactive or prospective only application. Thank you, Your Honors.
Thank you. All right, we'll move to the last issue, which is which agency might be ultimately responsible for any refund in this matter. And Mr. Klaus, you're leading off on that, aren't you?
I will. I'm going to give Mr. Frazier just a second to...
All right.
Let's play musical chairs, Your Honor.
Good morning, Your Honors. Again, I'd like to reserve 2 minutes for rebuttal if possible. Scott Claus representing ASTA. If the court orders a refund, which it shouldn't, the manner in which a refund must be paid is guided entirely and prescribed entirely by statute. ARS 42-1254D states that any appeal that is taken to a tax court is subject to the provisions in subsection 5, which states that if a final judgment is rendered, the balance due the taxpayer shall be certified by the Department of Revenue to the Department of Administration. On receipt, the Department of Administration shall draw a warrant payable to the taxpayer in an amount equal to the amount of tax found by the judgment to be legal, less the amount of any taxes. That is where the inquiry of this court must end. The statutory mechanism by which any refund ordered by the court would be paid is categorically prescribed by ARS 42-1254. Not only is the court guided by what that statute says, the court is guided by what is absent from the statutory scheme that created ASTA. ASTA has no tax levying ability. ASTA cannot levy taxes. ASTA cannot collect taxes. That is what distinguishes ASTA from real municipalities, towns, and counties that do have the ability to replenish their coffers. From the most fundamental way of looking at this, Your Honor, there is a bucket of money that is empty and is going to stay empty because ASTA has no constitutional or statutory ability to refill that bucket. That is why the tax court erred when it stated that ASTA was required to reimburse DOR. There is no mechanism by which to reimburse DOR, but more importantly, Your Honor, requiring ASTA to reimburse DOR would require ASTA to violate the organic statutes that created it and the statutes that prescribe the way in which every penny that ASTA receives must be spent. There is a statute that prescribes every penny of how the taxes received from the car rental surcharge tax must be spent. There are no pennies left over, Your Honor. There is no statutory mechanism that allows ASTA to repay DOR, and requiring repayment would require ASTA to violate its own statutory scheme. I will leave it at that, Your Honor, to reserve time, but the statutes are clear, the statutes are unambiguous. Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. Eric Frazier on behalf of the Arizona Department of Revenue. Any refund in this case should come from ASDA, not the Department, and I'd like to jump right into the statute, which is ARS 42-1254. That statute is an administrative and a jurisdictional statute that does not justify refunds in this case. We know.
1 second, counsel. Tom, you started the wrong clock there.
I'm happy to use his time, frankly.
Well, yes.
Do I get extra time?
No, we're just, all right, very good.
All right, here we
Please
go.
proceed.
We know that 42-1254 doesn't justify refunds here for a number of reasons. First of all, that statute and its predecessors have existed for more than 80 years, and no opinion has ever relied on that statute to justify refunds in a context like this, where the state did not levy or receive the funds from a statute or from the tax. By its own terms, in addition, that statute applies only if the tax itself was found to be illegal. And here, again, it's not, if there's any issue with the tax, it's not the legality of the tax, it's the expenditure. We also have, the Copper Hills case and so on, which also arose under 42-1254. Again, the court did not order refunds from the state or from the Department of Revenue, but from the entity that levied the tax and received the funds from the tax. I'd like to address the point that Mr. Claus made about whether ordering refunds from ASTA would violate ASTA's organic statutes. It would not. ARS 5-804 enables ASTA to sue and to be sued, which necessarily means that it can satisfy any judgment of the court. That's just like if ASTA was found liable for something like a breach of contract or employment discrimination, it could, of course, pay money damages, even though the legislature has dictated where the money goes. It has to be able to pay those judgments ordered by the court. We know that that any refund here should not come from the department for other reasons as well, because that would be very unfair to the 2.6 million Arizonans who live outside of Maricopa County and had no vote in whether to impose the tax. By statute, the department collects all transaction privilege taxes from counties and cities and towns throughout the state. So imagine that the town of Paradise Valley, for example, imposes a transaction privilege tax that's later found to be illegal. Ordering the state to fund that refund would impact the residents of Payson and Bisbee and Yuma and Globe, even though they had no ability to vote on whether to impose the tax. Here, no one outside of Maricopa County had any ability to vote on whether to impose the ASTA tax, so it would make no sense to justify this Department of Revenue in the state of Arizona to pay those refunds. My last point, Your Honors, is that the Department of Revenue here had an extremely limited role in administering the taxes. Again, the state did not levy the tax, it did not receive or retain the revenues. The department merely collected the tax and then distributed it every month. It distributed all of the revenues that it collected from the ASTA tax, and it was bound by statute to distribute them to ASTA. So under Copper Hills and other cases, that means that the department should not have to pay the refunds. We ask that you order that ASTA is responsible for any refunds in this case.
So Copper Hills is the case, in your view, that we should look to?
Yes.
Okay.
Thank you.
Thank you, counsel.
Good morning, Your Honor. Your Honor, the state legislature created ARS 5839. The state legislature created the taxing scheme. The state legislature created the taxing rates.
And enabled it.
And enabled it. Not the authority, not the county, not the electors. The state created. You see, implicit in the argument and expressed in the briefs is the notion that this is somehow a local tax. It is not, and again, we look to the statutes to know that. ARS 42-5001 subsection 19 contains the definition of the taxpayer for which this case exists. The taxpayer means any person who is liable for any tax which is imposed by this article. This article is Article 5. Article 5, 42-5032.01, specifically talks about the department's duty to collect and administer the taxes for the car rental surcharge, for the stadium district. Those taxes are not local taxes, and we know that again by reference to the statute, because Article 6 deals with local taxes. Article 5...
But they're local. They're approved by Maricopa County voters. They're only charged to Maricopa County car rental companies, right?
They are charged irrespective of the domicile of the car rental companies. They are paid by the car rental companies, and the tax itself was not created by the county, and the tax itself was not created by the authority. The tax itself was created by the state, and DOR has more than a mere administrative role in collecting the tax. It must also disperse that tax. But here's the last point that's most important, Your Honor, which is 5835. Your Honor, Mr. Fraser talked about 804, which says that the authority can sue and be sued. But 835 prescribes the manner in which the revenue derived from the car rental surcharge must be spent, and not one penny of that is left to be refunded. That's the statutory guidance that the court should look to. So in the event that any refund is ordered, it should not order as to be liable for that, Your Honor. Thank you.
All right. Thank you, counsel. And thank you for the excellent and extensive briefing in this matter and the vigorous arguments here today. And we also express our appreciation for the several briefs filed by Amici in this matter. We found them to be very helpful, along with the parties' briefs as well. We'll take this matter under advisement. We'll issue a written decision in due course. And with that, we are adjourned.